Okay, picture this. A contractor walks off the job with your money. Or maybe a landlord unfairly withholds your $2,000 security deposit, even though you left the apartment in absolutely pristine condition. You're angry, right? And you want your cash back. Well, in today's explainer, we are breaking down exactly how you can get it back without having to spend a total fortune on a lawyer. So if you're out a few $1,000s, you usually run into this really common roadblock. Hiring a lawyer to fight for you might actually cost more in hourly fees than the amount you'd ever actually recover. It's a classic catch-22, and honestly, it leaves so many people feeling completely stuck, like they just have to swallow the loss and walk away. But hey, here is the good news. You really don't have to walk away. The state of Illinois actually custom-built a simplified, fast-tracked court system that is specifically designed to empower everyday citizens to recover their own money. It's called the Small Claims Division of the Circuit Court. It cuts out the formal discovery, it simplifies the pleadings, and most importantly, it's meant to be navigated by you without needing a law degree. To help you out, we've put together a clear roadmap for today's explainer. We're going to cover 1. Small claims court basics, 2. Preparing your case, 3. Filing and fees, 4. Serving the defendant, and 5. Hearing and outcomes. So let's jump right into Section 1, Small Claims Court Basics, and specifically, knowing your limits. First things first, the absolute maximum you can sue for in Illinois Small Claims Court is $10,000. And just to be clear, that figure is strictly for the actual damages you suffered. It doesn't include court costs and interest. Now, if someone owes you, say, $12,000, you have a choice to make. You either have to formally waive that excess $2,000 to use this fast-tracked system, or you've got to head over to the standard, much more complicated civil court. Oh, and a quick warning on a super common pitfall, there is absolutely no way you can split a $12,000 claim into 2 separate smaller lawsuits just to cheat the system. It doesn't work like that. You've also really got to watch your timeline for filing. What's fascinating here is that Illinois actually has the longest statute of limitations for written contracts in the entire United States, a whopping 10 years. Literally, you could have a kid and send them all the way to the 4th grade before your window closes. That being said, oral contracts and property damage give you a 5-year window, and personal injury claims give you just 2 years. But look, even with those generous timelines, it is never an excuse to delay. All right, moving right along to Section 2, Preparing Your Case, which is all about gathering the facts. So in civil court, the burden of proof is entirely on you, the plaintiff. You need to gather every single piece of evidence you have to meet what the courts call the preponderance of the evidence standard. Now, in plain English, that just means you have to prove it is more likely than not that your version of events is true and that you are owed this exact amount of money. Gather everything, your unpaid invoices, your emails, those text messages where they promised they'd pay you back, itemized repair receipts, the whole shebang. Because let me tell you, handwritten notes or a vague he said, she said argument, that is rarely going to hold up against actual documented receipts. Vague estimates will lose to a flat denial every single time. And here is a massive, incredibly crucial pro tip for your evidence. Always, always use the rule of 3. The court still operates heavily on physical paper during these hearings, so you need to bring 1 physical copy of every contract photo and receipt for the judge, 1 copy to hand to the defendant, and 1 copy to keep for yourself so you can actually follow along while you're testifying. Okay, so you've got your case prepped. That brings us to Section 3, Filing and Fees. Let's talk about making it official. You're going to be filing your case pro se. That's really just legal jargon for representing yourself. And Illinois is actually pretty unique when it comes to this. See, while most states force business entities to go out and hire lawyers, in Illinois' small claims court, even a corporation or an LLC can appear pro se through an officer or an employee as long as the claim is under that $10,000 mark. It is a huge cost saver for small businesses. Now, filing a lawsuit obviously isn't free, and the fees actually vary wildly depending on your location. Generally, you have to file in the county where the defendant lives or where the incident itself happened. So, for downstate counties, think McHenry or Madison, you might pay somewhere between $89 and $264. But if you're filing up in Cook County, yep, expect to pay significantly more, ranging from $204 to over $360. Honestly, though, if you truly cannot afford that filing fee, you're not totally out of luck. You can submit an application for waiver of court fees to the clerk, and the judge might just let you file for free. The actual steps to file are pretty straightforward. You fill out a small claims complaint form, but listen to me on this. You must ensure you have the exact legal name and address of the defendant. This is so critical, especially for businesses. Suing a place like Bob's Burgers when the legal LLC is actually Robert Dining Incorporated, that mistake can get your entire case thrown right out. Exact legal names. And here's a neat little shortcut. If your claim is under $2,500, Illinois Supreme Court Rule 282 provides an even simpler, fast-tracked complaint form. Once it's all filled out, you can file it in person or just do it electronically through the statewide Odyssey e-file IL system. Filing is just the beginning, though. Now we hit Section 4, serving the defendant, which means giving proper notice. Along with your complaint, the court clerk is going to issue what's called a summons. This is an official court order demanding the defendant's attention. And this is serious. If you fail to provide this proper documented notice, which the courts call service of process, the judge legally cannot proceed. They will simply dismiss your case right there. So how do you deliver it? Well, you've got a few options. You can pay the county sheriff roughly $35 to $60 to hand deliver it. For small claims, Illinois also lets you use certified mail with a return receipt requested. Or you can hire a private court-appointed special process server. But here is the absolute most critical rule of this entire step. You, the plaintiff, can never hand the papers to the defendant yourself. No way. You cannot put on a disguise and ambush them in a parking lot. A neutral third party has to do it, and then they have to file a formal proof of service with the court. And once they're served, we arrive at Section 5. Hearing and outcomes. This is your day in court. Look, if you were nervous about going to court, take a deep breath. Small claims hearings in Illinois are specifically designed by the Supreme Court to be informal. There are no surprise witnesses jumping up, no dramatic TV gotcha moments. When it is your turn to speak, just clearly tell your chronological story to the judge. Skip the emotional rants, skip trying to use fancy legal jargon. Just present the facts, show your itemized damages, and hand over your 3 physical copies of the evidence, just like we prepared for earlier. Okay, so let's say it goes perfectly and the judge rules in your favor. Congratulations. But here is a major reality check. The judge handing you a piece of paper that says you win, that doesn't magically teleport cash into your bank account. The court does not collect the money for you. If the defendant is stubborn and still flat out refuses to open their wallet, you have to actively enforce that judgment. But don't worry, because Illinois gives you some incredibly powerful post-judgment tools to force their hand. You can request a wage garnishment to pull money right out of their paycheck. You can levy their bank accounts or even place a lien on their real estate. You can also file what's called a citation to discover assets. Basically, this legally forces a stubborn debtor back into court to reveal all their finances under oath. And if they ignore that, it can actually result in a civil arrest warrant. Plus, just so you know, your unpaid judgment racks up 9% interest every single year. One quick caveat to keep in mind, whether you win or lose, both sides have a strict 30-day window to appeal the judge's decision if they feel an actual error in the law was made. But keep in mind, an appeal isn't just a free do-over because someone didn't like the result. It requires filing in a higher appellate court, which, honestly, usually means it's time to bite the bullet and actually hire that lawyer. So let's step back and look at how this builds into a complete picture. When you break it down into predictable, chronological steps, filing the proper complaint, legally serving the summons, organizing your evidence using the rule of 3, clearly presenting your facts to the judge, and then utilizing those post-judgment collection tools, a process that originally seemed incredibly intimidating is suddenly entirely within your control. Remember, this system was explicitly designed so everyday residents and small business owners aren't priced out of getting justice. The next time someone breaches a contract or damages your property, just remember that you absolutely have the tools to stand up and claim what is rightfully yours. Now, before we wrap up, please keep in mind this explainer is for educational purposes only and doesn't replace the advice of a qualified attorney for your own unique situation. But I do want to leave you with this final thought. The next time someone wrongs you and refuses to make it right, are you going to let intimidation stop you and just walk away? Or will you use the system built specifically for you to get it back? Thanks for joining us for this explainer, and hey, good luck out there.